Hello, future legal eagles. Welcome back to the channel where we break down complex legal concepts into bite-sized chunks so you can master them. Today we're diving into a case that is as sweet as chocolate and as catchy as a good tune. Chappell and Company Limited versus Nestlé Company Limited. Want to join us? Well, grab your legal briefs and let's get started. Once upon a time in the 1950s, the one and only Nestlé decided to play a little game with the hearts and wallets of music lovers. Here's how it went down. They came up with a brilliant idea, or maybe not so brilliant, depending on who you ask. They decided to team up with some music publishers like Chappell and Company and offer customers a chance to get their hands on some free music records, which we know now as vinyl records. The way it worked was pretty simple. You'd buy a few chocolate bars, save those shiny chocolate wrappers, and send them off to Nestle along with a small sum of money, usually a few pence. And in return, Nestle would send you a free music record. Sounds like a pretty sweet deal, right? Well, it was for the customers. But the music publishers weren't exactly over the moon about this arrangement. Why, you ask? Well, they didn't think that Nestle was paying enough to have the records. They argued that the chocolate wrappers were part of what customers were paying for the records, and therefore Nestle should pay more royalties based on the value of the wrappers. Now, here's where things get interesting. The music publishers took this dispute all the way to the House of Lords, the highest court in the United Kingdom at the time, because they wanted the court to rule that the chocolate wrappers were part of the consideration for the records. Consideration in contract law means something of value that is exchanged between the parties. Usually money, but it doesn't always have to be money. It could be a promise to do something or to not do something. So the big question before the House of Lords was whether the chocolate wrappers, which seemed pretty worthless once used, could actually count as part of the consideration for the music records. To answer this question, let's look at the rule. Specifically, the doctrine of consideration. This doctrine is a fundamental principle in contract law, that something of value must move from the promisee, that is, the person who receives the promise. In simpler terms, if you want to have a valid contract, there must be an exchange of value between the parties. Now, you might be thinking, great, so far. But here's where things get a bit tricky. The doctrine of consideration doesn't say anything about whether that exchange has to be fair or equal. It just says that there has to be an exchange. That's why the law doesn't require consideration to be adequate, only sufficient. In other words, it's enough if the consideration is simply worth something in the eyes of the law, not necessarily in the eyes of the parties or anyone else. So let's apply this rule to our delicious dispute. The House of Lords had to decide whether the chocolate wrappers, even if seemingly worthless, could constitute sufficient consideration for the music records. After careful deliberation, they decided that yes, they could. In reaching their decision, they considered the economic and commercial significance of the wrappers. They noted that the wrappers were what induced customers to buy more chocolate bars, thus boosting sales, and that was the whole point of the exercise for Nestle. In exchange for the records, they were getting something of value. albeit something that was not easily quantifiable in monetary terms. This case is important because it is a classic example of the courts not getting involved in measuring the adequacy of consideration. They don't care if one party gets the better end of the bargain. They're only concerned with whether there is any consideration at all. So in the end, the House of Lords ruled that the chocolate wrappers were part of the consideration for the music records, and that Nestlé did not have to pay more royalties. And that, my friends, is the sweet taste of justice. We hope you enjoyed this chocolate-coated journey through contract law. Remember, when it comes to consideration, it doesn't have to be adequate, just sufficient. Don't forget to hit that subscribe button and ring the bell for more legal insights. Thanks for tuning in and happy law studying. Until next time.